All right, counsel, let's begin.
Good morning. May it please the court. My name is Kelly Gonzalez, and I represent the defendant appellant, the Ralph Mahar Regional School District, which serves approximately 800 students in the central Massachusetts towns of Orange, Windle, New Salem, and Petersham. This case is before this court on 3 certified questions that were certified by Judge Ponzer of the Federal District Court. The 3 questions generally concern whether a contract for the procurement of electricity between Mahar and an energy broker named Northeast is subject to Chapter 30B, one of the state's bidding statutes. The question is whether 30B applies or whether the contract is exempt from the requirements of Chapter 30B under an exception for contracts for energy or energy-related services.
Let me answer this question. If Mahar Regional School had directly contracted with Constellation for the energy, would it be exempt?
It would not be exempt. Excuse me, it would be exempt. Pardon me. I got that reversed.
So if they had actually basically gone to Constellation directly and said, we're going to buy it from you, they're exempt.
Correct.
But isn't the contract in question, doesn't it, I mean, it sets the hour that the price per kilowatt hour that the Constellation, I mean, isn't it one in the same contract? Don't they get combined?
There's a separate contract with Constellation that Northeast signed on behalf of Mahar, so there's 2 separate contracts. But the reason why the contract with Northeast is central to this question is that there's an agency relationship established between Northeast and Mahar, where Northeast becomes Mahar's agent. So Northeast entered into the contract with Constellation on Mahar's behalf without Mahar signing or otherwise authorizing that contract.
Can you have a difference in it depends on sort of what the agent is supposed to do, this energy broker is supposed to do. But if the energy broker does more than just procure the energy supplier, but stays on top of this relationship throughout it, doesn't there have to be an overlapping of the terms of the contracts? That is to say, the municipalities, the schools, contract with its agent, and the agent's contract with the energy supplier. Don't they have to be sort of coterminous if that relationship is to work? And therefore, if that's the case, can you really just limit it to 3 years?
I would suggest 2 things. First, there's no evidence on the record that Northeast does any other work for or did any other work for Mahar here other than simply entering into the 2 contracts. They did ask for additional information on the amount of energy that Mahar uses so that it could enter into the second 2008 agreement with Constellation. But we don't know of any continuing services that happen in between there. I understand that Bay State, another contractor, has submitted an amicus brief where it says that it does a lot of those kinds of things. First of all, there are other exemptions to Chapter 30B that could apply to Bay State, for example, a sole source exemption. But even under this exception, I would posit that no, they don't need to be coterminous. Chapter 30B is certainly a bar. It makes things more difficult for everyone involved. But it doesn't mean that the energy broker couldn't go before the school committee here or a town council and say, look, your contract's about to expire. We still have a term, or the electric, you still have a contract with the electric company. We would like to be coterminous with that. Please renew it. I mean, there are provisions. It's not saying that you can't renew it at all. It's just that you can't automatically renew it. And there's also, one of the legislative purposes of this exemption to Chapter 30B, it was added from the 1997 Restructuring Act. I think there's no dispute or no question that the Restructuring Act, which changed the electric system in this Commonwealth from regulated to a more competitive system, it was aimed at saving consumers money.
I guess I'll ask a quick question so I can understand.
Sure.
Are we also dealing here with Chapter 164, Section 134, the aggregation of municipalities? Is that not, those language in that has no implication for what happens here?
Well, certainly municipalities can aggregate to get
Here's why I asked the question, because I was looking for, obviously the question here is related, whether it's related and whether you're exempt or not. And so if you aggregate, it says that a municipality may group retail electricity customers to solicit bids and broker for certain things. And then with respect to other things, they may enter into agreements to facilitate the sale and purchase of electric energy and other related services. So they seem in that provision to distinguish between things which you can solicit bids for which includes, I think, brokerage. And then the other thing, which we're talking about, which is to facilitate the sale and purchase of electric energy and related services. And so if those two are distinct, because they're two separate sentences, then I think you can look elsewhere in the scheme where you have some descriptions, although they're not identical, to what is a related service to energy. But I just wasn't sure whether your argument was that you can look into this elsewhere in the scheme to see if these two concepts were segregated anywhere. The solicitation for bidding, the solicitation for brokerage and those kinds of services as distinct from energy.
I'm not sure I fully understand your question, but I'll try to answer it based on what I do understand. I don't think we're arguing based on any kind of legislative history or the language of the statute itself. I think that's all pretty unclear, quite frankly. Nothing in the statute or the legislative history says what the legislature meant by energy-related services or how it thought that it would serve the purpose of saving consumers money when it deregulated the electric system. So the fact that municipalities can band together, that's certainly true, but you don't need a broker to do that. Municipalities can certainly band together informally. You can form a trust. I know that there are several places in the Commonwealth right now, for example, the Berkshires are having a wind farm and their towns are banding together to procure wind electricity.
So if the municipalities band together for, and would that be the aggregate energy? I don't know if that's at least the 30B, Section 132. Is that what an aggregate energy contract would be?
I think it could be, yeah.
Okay. So if they band together and they retain the services of a broker, you're saying that, and let's just say there's 5 municipalities that band together to do that, retaining one broker, that each one of them on whatever, that each one of them has to renew, separate renewal every time. Is that right?
By every time, every 3 years it would be, because that's the limit.
Yes.
Under 30B, yes. And the reason why, and this is obviously the point that I think Justice Gantz was getting at, is there is a difference between an electric company and a broker. The bottom line is that a broker just simply isn't necessary. It's a middleman. They drive a commission off of this, they make a profit.
Yes, but the fact is that they, I mean, are cities and towns really in the capable? I mean, it's not really, has not been their business to start negotiating and trying to do this kind of work with respect to energy companies, where you can really negotiate over the price, because that wasn't the case really before it was really what price the regulated utility was going to give you, right?
But they can. For example, Superintendent Baldessari, who is the current superintendent of the school district, when this case first started, he did contact a couple of energy companies, and he found a rate approximately half the rate of what they're being charged today.
Well, that's what brings you to this lawsuit, correct?
Exactly. Again, part of the problem here isn't just that the rate was raised by 75%. It's that we were locked in for 5 years and can't escape it. And that's costing the tax.
You can't escape it because you didn't catch it.
That's the product of these kinds of contracts. You can stabilize your budget over time, but sometimes the market collapses and you end up paying more than you could have if you just done month to month. I mean, that's the risk and the benefit.
And don't you also have the problem here that you missed the notice?
Yes, there's no excuse for not responding or not noticing a letter. I will say that it was sent in the middle of the summer, and the school district was given 15 days, and I don't think very many public entities respond in that short period of time, but certainly a school district is responsible for checking and responding to its mail. But that's why 30B exists. That's why there are limits on automatic renewals. That's why there's term limits. The bottom line is that this costs taxpayer money. This is a school. This is teachers who are being laid off. This is educational programs that can't be funded, basically because someone dropped the ball and didn't notice a mailing that gave them 15 days to respond. That's why 30B exists, is to protect the public coffers and to make sure that there is some protection here.
But I guess part of my problem is you've told us that if Constellation Energy had said, we'll sell you energy for X per kilowatt hour, they're not required to bid. If a broker comes and says, I'm a broker for a number of school districts, and I can aggregate their purchases, and I can get a deal from Constellation for X per kilowatt hour, and what my cost to you are zero because it's incorporated in the X, why would the law say it's different?
I have two reasons, and first of all, I think that, I know that Northeast has said numerous times that its commission is paid by Constellation. We don't have the exact details on that, but
Okay, well, you
know
certainly
it
weren't
is.
paying any extra. I mean, you didn't. I mean, you were paying a price for the electricity. You were not paying any money above and beyond that for the broker, were you?
No, but I assume that the commission rate is passed along to the consumer ultimately.
Okay,
through
well, let's assume it
Constellation's
is,
charge.
but it's still,
let's
as far as
assume
you're
it is.
concerned, it's still X per
Right.
kilowatt hour, and that's the same thing it would be if you had gone directly to, maybe less than it would be with the aggregation if you had gone directly to the energy company. So why should the legislature have meant for that to be treated differently?
I think there's two reasons. The first is that and this is sort of what the Inspector General, I think, was getting at when it was distinguishing between services that are necessary or ancillary to energy versus services simply for the sale of energy. If you can't reach an agreement with an electric company, for example, because the 30B process obviously is time-consuming and more difficult, or if the contract is about to expire and a school committee or a town council hasn't gotten its act together enough to renew it, there's a chance that a school or a public building is going to be without power. There's no such risk with an energy broker. If our contract with Northeast runs out, we can certainly contact Constellation and Star or any other number of energy providers. So there's no risk of the lights literally going out in a school if the contract expires with the broker. The second reason is this agency relationship. It's a special relationship. All of us get our electric bills, and I think we scrutinize them knowing that the electric company is acting in its own behalf, as certainly as it's right. When you have an agent, you expect the agent to be looking out for you, as they're required to do under their fiduciary duty.
Well, but you're not alleging, are you alleging a breach of fiduciary duty? Maybe I missed that.
We are below, but it's not directly relevant to the certified questions here. So obviously, to the extent you can kind of put a few more protections at the beginning of the relationship and limit the length of the relationship to make sure that the public coffers are protected, then the agency relationship is a little bit less concerning. I mean, here we signed a contract in 2004, amended in 2005, and we're locked in until 2013 into a contract that we haven't wanted to be in since 2008. So I would submit that certainly a school would be more, a contract with the energy company would be subject to more scrutiny than some kind of mailing, which here it looked like a mailing, a solicitation, a marketing ad sent by its agent.
But as to that latter point, you could have entered, we keep coming back to the same thing, but I mean, you could have entered into a 5-year contract with the energy company directly, and you might not have liked that since 2008. There's nothing to complain of, though.
Correct. In that case, 30B does not apply.
Right.
So we would be subject to that contract. But I would submit that we would have to have affirmatively entered into that contract.
Well, you did have to affirmatively enter, I mean, the renewal, no, but you did have to affirmatively enter into this contract. I mean, if, for example, to take Justice Lank's example, let's say it was the exact same thing, only direct. So there was a renewal provision, says you've got 15 days to agree, and it's in the middle of the summer and you miss it. You would have nothing to say, correct?
Well, I think we would still have our breach of implied warranties.
Okay, all right. But I mean,
the
you'd have
claims
nothing
here,
to say in terms of the 30B.
correct. I think we would be stuck.
So,
Like I said, I think there's a difference. I think that the Inspector General noticed that difference. That's basically what we're relying on. I mean, we were concerned about this. We called the authority who's responsible
the
for this.
Inspector General, I mean, I know there's some dispute, but in fairness, the position that he took with respect to your contract seems to be unique in the view of the Inspector General over time about this particular, what happens with these broker contracts.
I would respectfully disagree. In 2005, there's a bulletin that says that contracts with energy consultants are subject to Chapter 30B. And then in 2009,
But
there's
you
another
yourself
publication.
had one that wasn't under 30B, didn't you? In 2000, isn't the original contract, you didn't do it under 30B, did you?
Correct, we didn't. And I will say that while the school district probably should have had counsel look at it, at the time they didn't have any lawyers look
And
at
isn't
the
that true of
contract.
most municipalities? They don't do it under 30B?
I couldn't answer that. I'm not certain.
Well, at least the ones that are filing the amicus brief.
It appears not, according to the amicus. But I wouldn't say that the Inspector General's opinion is, I think it's actually consistent. The only thing that has been presented that is suggests the Inspector General has been inconsistent is this guest affidavit, which Northeast got at the 11th hour and tried to submit. But it's uncorroborated hearsay. I submit that this shouldn't be any kind of basis for finding that the Inspector General has been at all inconsistent.
What then do we make of the Arlington advice?
I think it's just a holding pattern. Nowhere in that letter, I assume you're referring to the recent 2010 letter.
Right.
Nowhere in that letter does the Inspector General say, oh, no, you don't need to meet the requirements of 30B anymore. In fact, it says, we suggest you do. It just says that because of this precise litigation, which the underlying litigation is cited in that letter, because of this litigation, we're reserving comment. The Inspector General certainly knew this question was coming to this court and it was going to be resolved, and that there was a chance that the court would resolve it. Energy prices right now are favorable. The Inspector General wanted public entities, all of which are struggling with budgetary problems, to be able to take advantage of the favorable prices, and just said we're instituting a holding pattern. So that was a prudent action as opposed to a reversal, of course. I see that I'm out of time, so if there's no other questions.
Thank you.
Thank you, Owners.
Good morning. May it please the Court, my name is Scott Birnbaum. I represent the appellees, Northeast Energy Partners, LLC, and Constellation, NewEnergy. In 1997, the Massachusetts legislature adopted a new regulatory framework for the provision of electricity in the Commonwealth. In this new framework, the legislature declared that competitive producers will supply electric power, and customers will gain the right to choose their electric power supplier. And the legislature intended that by the term customer, it included not just residential consumers of electricity, but municipal entities such as Mahar. Yes, Your Honor.
I can wait on this, but at some point, I just have this big question in my mind. If I accept your argument as to what was intended with 1B33 and 1B32 enacted as part of that, what do I make of Section 6K of 30B that was also added at the time, which 6, as I understand it, but that's what I'm going to ask you, is about entering into contracts, and 6K talks about entering into, competitive bidding contracts, and 6K talks about entering into contracts for energy-related services. And I guess my question is, if you're right that 1B33 exempts this kind of energy-related services, and this would be included, why is it included in 6K?
Well, Your Honor, energy-related services is, as both parties agree, a broad term.
Right.
And Section 6K provides a optional procedure that municipalities.
How do you know it's optional?
Well,
I'm not challenging you. I just don't know how you know that.
Well, because I believe it uses optional language. I believe it uses language that what municipalities may do, if I'm remembering correctly.
Well, it may in terms of these particular provisions, but the fact that it's there suggested to me that the legislature was thinking that these kinds of contracts would be under 30B. Why would they talk about it in 30B?
Well, Your Honor, very clearly in Section 33, there's an exemption for energy-related contracts. So there's no question that the legislature intended to exempt, by the plain language of 33, energy-related contracts are exempt. And so the question is, well, what is Section 6K do? And I would suggest that for certain categories of energy-related contracts, it provides an optional procedure that municipalities can follow for bidding. But it doesn't. But it is not intended and does not state that it applies to all energy-related procurements. So there may be certain categories in which it makes sense to pursue this policy. But the legislation nowhere says that 6K is applicable to all energy-related contracts. And I think the fundamental question, Your Honor, is, I think that's raised, is does the phrase energy-related contracts apply to energy brokerage services? Is that an energy-related service covered by Section 33? And I think Justice Gant's initial question really poses the stark question that I don't believe Mahar has a reasonable answer for, which is why would it make sense for the legislature to permit municipalities to contract directly with with energy providers, when the legislature clearly wants municipalities to be players, to be active participants in this new deregulated electricity market. And why would the legislature then want to hinder municipalities, tie one hand behind their back, and deny them a tool that a broker represents, as explained in greater detail by the brief of the amici? That simply makes no sense. So what we have here, Your Honors, is a statute that, by its terms, by its plain language, applies to energy brokerage contracts. My sister and Mahar never argue that the plain language of the statute does not apply to energy-related contracts. There is no contention like that from Mahar. Instead, what Mahar argues is that that term, energy-related services, is so broad, that it is meaningless. In other words, it should be ignored by the court. Now, that's a novel contention. In fact, Mahar...
I mean, don't you, I mean,
Yes,
what
Your
I
Honor.
took it to mean, well, insofar as Mahar adopts the argument of the, or the analysis, I should say, of the Inspector General, in fact, it's saying energy-related services is very narrow. I mean, it's really connected to the, load requirements, whatever else. It's very directly energy-related.
Well, Your Honor, I believe Mahar's argument is because the language is so broad, there's no way of knowing what it means, and so the only guidance available to anybody is the Inspector General. I think that's the argument.
Right, but then you get to that substance.
Yes, but just the principle that this principle of statutory construction that you can ignore language because it's so broad simply does not exist in the law. There's no case that stands for that proposition. It turns the normal statutory construction canons about giving effect to all the language of a statute on their head. I'm happy to address the Inspector General and why that should be given no deference at all. For many reasons, not least of which, based on the Arlington letter, it no longer represents the view of the Inspector General. The Inspector General has stated that it is now suspending advice. It's now reserving comment on the energy exemptions and the applicability of Chapter 30B to the services of an energy broker.
This is waiting for this litigation.
Regardless, Your Honor, right now there is no advice from the Inspector General in effect. So the only thread upon which Mahar rests, the only support it has is the statement of the Inspector General, which is now being reserved. But even if that were not the case, even if the Inspector General's views were still alive and active, for numerous reasons, Your Honor should give it no deference, not least of which it is, by its own terms, an advisory opinion. In addition, it is unexplained. There is no explanation offered. There is no reasoning attached to it. It is in the very real sense, ipsy dixit, the inspector. Yes, Your Honor.
Well, I thought, and maybe I misunderstood the argument that you made or Amici made, that you did take the position that this view in the letter of 2010 was made in response to this particular problem that was actually a change of view of the Inspector General. But maybe I'm just misreading what you intended.
Your Honor, I'm happy to clarify. The position that we take, and I believe that is supported by the record, is that until 2010, when the advisory decision, the advisory letter from the Inspector General was issued, the Inspector General had never taken the position applying Chapter 30B to contracts with energy brokers.
So it isn't that he said it doesn't apply. He just had been silent on the subject.
That is correct, Your Honor. And the guest affidavit, which Judge Ponzer permitted to be filed in the district court, substantiates that in 2006, the Inspector General told the city of Marlborough that so long as they were dealing with a licensed energy broker, that the Inspector General's position was that Chapter 30B did not apply. Now, I need to comment very briefly on the reference to the bulletin from 2005 that my sister mentioned. That bulletin was not, Mahar did not include as part of the record appendix, but the brief of the amici, fortunately, did attach it as part of their addendum. And if Your Honors were to look at that, you would see that what the Inspector General refers to in that bulletin are energy consultants, not energy brokers. And there's an important difference, Your Honor, because as part of the 1997 energy restructuring legislation, the legislature enacted a new statutory, regulatory and licensing scheme for energy brokers, of which Northeast is one, as well as one of the amicis. The energy brokers are licensed and regulated by the Department of Public Utilities. They play a particular role in terms of procuring contracts. Consultants are not regulated, they're not licensed, and they may perform any variety of services. Anyone can put up a shingle and call him or herself a consultant. So there's no public guidance prior to 2010 from the Inspector General or from anyone else that suggests that licensed energy brokers are subject to Chapter 30B. So, but getting back to the point about what deference, if any, should be given to the views of the Inspector General, it was not issued as part of any sort of rulemaking function. The Inspector General has no rulemaking authority. It was not issued as part of an adjudicatory function. And interestingly, the Inspector General does have an adjudicatory function. It has the right, if it suspects there is a violation of law, to request the Attorney General to authorize the Inspector General to pursue civil proceedings against the violation. That did not happen in this case. What's more, yes, Your Honor.
One part of your argument baffles me. You say, why would the legislature exempt, or why would the legislature not wish brokers to be included, because why would they deny them the advantage of the new competitive electrical system, or energy system? But the market for construction contractors is competitive, and we don't say they're exempt. We say bid for the lowest price within the contours of what you want. And why could they not enjoy the benefits of the competition in a bidding scheme?
Well, what Your Honor is suggesting is a competition among the class of brokers, not construction companies. And so so what's comparable to the construction companies are the utilities, the providers of the service. And the legislature made a judgment that that competition should occur, but it should be unhindered by the constraints of public bidding process. And what I would suggest, and I had understood Your Honor's earlier question to also query about, is what is the logic to require brokers to be subject to public bidding, but not the contractors, the energy providers whose services that are being procured, that the broker is being hired to place? I don't see a logical reason and a logical explanation for why the legislature would want to make that distinction. To the extent the legislature is concerned about the role of middlemen, they address that through the licensing and regulatory process of the Department of Public Utilities. There are now regulations in place that deal with the licensing of these entities. Your Honor, the last reason why the Inspector General's views should carry no weight is that it simply is wrong. The Inspector General essentially equates, says that what energy-related services mean, what that phrase means, is essentially the same thing as ancillary services, services that are ancillary to the delivery of electricity. Well, as we point out in our brief, that term, ancillary services, is separately defined in the statute. In the Energy Act, it's Section 184. So quite simply, if that is what the legislature had in mind, it would have simply said Chapter 30B does not apply to energy contracts and ancillary services as a defined term. It didn't do so. It used the expression energy services or related services. What's more, there's a point that was raised for the first time in the amicus brief that was not responded to by the reply brief that I would direct Your Honor's attention to, and that is what happened in 2008 when the legislature revisited this complex question of energy deregulation. In 2008, the legislature enacted the Green Communities Act of 2008, which is a complex piece of legislation. But once again, they had occasion to use the phrase energy-related services in connection with that enactment. And at that time, the statute provided that municipalities could provide, quote, energy brokering and other energy-related services without losing exclusivity that municipal utilities otherwise had. So the fact that the legislature used that phrase, energy brokering and other energy-related services in 2008, strongly suggests that when the legislature acts in this realm, it treats energy brokering as one of among the class of energy-related services. And if that's the case, then energy brokering, which is precisely what Northeast Energy Partners does, is an energy-related services and accordingly is exempt from Chapter 30B. Thank you, Your Honors.